Yeah, it's good times. Weekend watching, I suppose. All right, well, with all that, we will go ahead and get underway. We are here now for argument in CV 20-0230, Donald versus ENG. As you are aware, each side will have your maximum of 20 minutes for argument, which you are not required to use, but you are welcome to use. Appellant, you are free to reserve some portion of your time for rebuttal, but you are responsible for managing your time. Due to the virtual nature of this argument, and we appreciate your accommodating us on that, I will be keeping manual time and I will alert you at various periods as to how much time you have remaining. If you would like an update at any time, feel free to pause and ask me that. You also may feel free to keep track on your own phone or own device of your time. As I mentioned, we will be recording this argument. In fact, the recording has already started. This recording will ultimately be posted to the court's YouTube channel. So for clarity of that record, we ask that you please identify yourself and your client when you begin speaking. We of course hope that despite our minor issues now, no major issues of connectivity occur. But if there's a connection failure and one of the judges drops off, we will continue with the argument and that judge will review the recording at a later time. If one of the attorneys loses connection, that will be a different case. We will suspend the argument until the attorney is able to rejoin. With all of that, we ask you to please keep in mind that we've read your briefing, we have looked through the record, and we have discussed the case in conference this morning. And with that, appellant, you may proceed.
Thank you. My name is Frank Murray. I represent Tim Donald and the American Soccer Marketing LLC. And I had made a couple of notes. First, it seems appropriate to apologize for my quarantine hair. I've never had hair this long in my life. I suspect a lot of people are like that. And it seems like I ought to say something about it. Secondly, I always disliked it when people argued their appeals by repeating their briefs, and I have no intention to do that. I think the matters are fairly covered by the briefs, and so are questions. I'm probably going to defer to Mark. And if he wishes to argue, of course he can, and I'll reserve time to handle any issues or questions that might come up later in the process. Uh-oh, I've lost the volume.
Am I the only one who cannot hear?
I can't hear her.
Oh,
Can you hear me now?
Yes.
Yeah.
Sorry, that was a user error on my part. What I was asking about is the other damages that Mr. Donald is claiming in terms of the thousands of dollars in attorney's fees. In terms of the record that is properly before this court, could you point me to something in the record other than Mr. Donald's own affidavit that supports those fee claims?
Yes, there's the declaration of Ms. Connie Mabelson, the attorney, to that effect.
Okay, and that establishes how many thousands of dollars in?
A little over $6,000.
Okay. Other than that, there's nothing properly before us to support damages beyond the loss of the franchise.
Yes, correct.
Okay. That's the question I have at the moment. Judge Cruz, Judge Howe, do you have further questions at this time?
No, I do not.
No, thank you.
All right, well, Mr. Murray, if you'd like to reserve the remainder, we'll do that. All right. Okay, Mr. Dangerfield, I guess the floor is yours.
All right, thank you. May it please the court. I'm Mark Dangerfield. I'm appearing today on behalf of Kyle Eng and his wife, Tamara Eng, who were the defendants in the trial court case. I might as well start with the question Judge Perkins asked and the response to that question. Mr. Murray said that the only thing in the record supporting additional damages was the declaration of Connie Mabelson, who indicated that in her declaration that there were some attorney's fees over a little over $6,000, I think was the way Mr. Murray explained it. In fact, though, the declaration of Ms. Mabelson that he referred to is not in the record. It was stricken from the record by the trial court judge. And we've explained that in our briefing. Even if it were properly in the record, as I say, the trial court judge struck it from the record, but even if it were actually in the record, the declaration, when you parse it, doesn't really support any additional damages based on attorney's fees. And the reason for that is this case, the claim in this case that relating to attorney's fees relates to a specific time period. And you've read the briefs, and so I don't need to go into great detail about that. But the time period begins on February the 10th of 2014. And according to plaintiff's claims in his complaint and since, on that date, Mr. ENG and Mr. Donald met and had a discussion about Mr. ENG's possible participation in the soccer partnership that Mr. Donald had drawn up, the ASM. And according to plaintiffs, they had a handshake deal that they would agree to a 51%, 50% split, or I should say 51-49 split. And then it's claim of the plaintiffs that at that meeting, my client, Mr. ENG, said, oh, let's have Connie Mabelson, your attorneys, Mr. Donald's attorney, drop the papers to save money because my attorneys, which is our law firm, by the way, are expensive. That's the claim. But when you actually look at the evidence, here's what the evidence shows. I told you that was February 10th. On February 11th at 1 in the morning, I was trying to get the, see if I had made a note of the exact time, but in any event, on February 11th, very early in the morning, Mr. Donald sent an email to Mr. ENG, and oh, here it is, 1:23 a.m. on the morning of February 11th. And he asked in that email, quote, do we want Connie, that's his attorney, Connie Mabelson, do we want Connie to provide agreements and Terry Thompson, Mr. ENG's attorney at the time, to amend to keep cost effective and expedite? So note, there couldn't have been an agreement reached on that point the night before because Mr. Donald is raising the question at 1:23 a.m. the next day as to whether, and he's proposing maybe we should have his attorney, Ms. Mabelson, draft those documents. That's at 1:23 a.m. That's at Appendix 200 if you want to make a note of that. And then at
Counsel, I believe you covered this factual playing out of these facts in your brief in some detail, so we are familiar with that.
Okay. All right, I won't go into further detail. I don't want to bore the court.
Yeah, I appreciate that. I guess maybe what would be appropriate is if you could talk to me a little bit about your position on the collateral estoppel, as Mr. Donald's counsel argued in his briefs. You know, there were different claims. How does that play into the collateral estoppel analysis?
Yes, thank you, Judge Perkins. I would be happy to discuss that. So the Mr. Donald's claim from the very beginning, along with that of ASM, his partnership, has been that the USL and Mr. ENG got together and sort of colluded to try and falsely terminate his franchise agreement, Mr. Donald's or ASM's franchise agreement, so that Mr. ENG could take it over and reap the rewards of that. That's kind of been the claim. So the key issue in the case is, did the USL actually wrongfully terminate that agreement, or did they properly terminate the agreement because of Mr. Donald and ASM's default under the franchise agreement? And that very issue was the central issue in the AAA arbitration. As the trial court ruled, I'm quoting now, whether or not the termination of plaintiff's soccer franchise agreement was wrongful was the central issue, close quote, in the AAA proceeding in Florida. So now the question is, what impact or effect did that arbitration ruling have in this case? Well, that's the collateral estoppel issue. And in the Cheney Building Company case, our state Supreme Court found 4 elements of collateral estoppel. The first was the issue or fact to be litigated, actually litigated in the previous suit. There's no dispute about that. That fact was that was the central issue, and it was litigated. Second one was a final judgment. Was a final judgment entered? Yes, a final judgment was entered in the arbitration case by the arbitrators, and then it was entered, it was blasted ultimately by the federal district court in Florida. So final judgment has been entered. The third element is the party against whom the doctrine is to be invoked had a full opportunity to litigate the matter and did litigate it, actually litigated it. Well, there's no dispute that Mr. Donald and ASM had a full opportunity in the AAA proceeding to litigate that issue. The hearing itself went on for 4 days before a panel of 3 experienced arbitrators. They had the chance to take pre-trial discovery. The witnesses were testified, including Mr. Donald. So Mr. Donald and ASM had a full opportunity to litigate that matter. And then the last element is, was such a issue or fact essential to the prior judgment, in this case, the arbitration award? And of course it was. That was the essential issue, was whether the USL properly terminated the arbitration agreement. And it did.
So counsel, if the matter was tried in Arizona and that factual finding from the arbitration was held to be dispositive, the claim could not succeed in the Superior Court. Is that correct?
I'm sorry, I missed part of that, Judge.
Sure.
Would you mind repeating that?
Given the finding in the arbitration, given the ruling that there was no impropriety, then if the matter were tried in Arizona, Donald could not succeed because he couldn't contradict that finding. Is that correct?
Correct. He couldn't try and contradict that finding in this court. That's the way estoppel works, and the collateral estoppel works, as you correctly note. And by the way, Judge, Mr. Murray in his briefs suggests that, well, it would be a different law would control here in Arizona. But that's not accurate either, because the law that would control whether the franchise agreement was wrongfully or properly terminated is spelled out in the franchise agreement. It's Florida law. And so whether that issue was tried in Florida or here, the court would have to, would be interpreting and applying Florida law because the franchise agreement requires that.
Is there any difference between Florida and Arizona law on this issue anyway? I mean, apart from the agreement.
Not that I'm aware of, not in terms of terminating whether the termination of the contract was wrongful or not. I'm not aware of a difference.
Thank you.
So
Council, you have just under 10 minutes.
Okay, thank you. So let me go to the argument that Mr. Murray has made, that even though the court determined that the arbitration panel determined the USL had the perfect right to and did properly terminate the franchise agreement due to Mr. Donald's default, that it was really ENG's fault anyway, because Mr. ENG caused the USL to terminate them, or something along those lines. That argument doesn't fly either, because the argument suggests that Mr. ENG was improperly talking to the USL, and there was nothing improper about Mr. ENG talking to the USL. Plaintiffs haven't cited any case or any legal theory that would prevent Mr. ENG, or would have prevented Mr. ENG, or made it illegal or improper for him to talk to members of the USL at the time that these discussions were going on. Mr. Donald himself was talking to 3 different people. He was talking to Mr. ENG to try and get a partnership agreement, but he was also talking to this group of Brazilian investors and a third party as well, all at the same time trying to get someone to agree to put in some money and join into this agreement. And there was nothing that barred any of those parties from talking directly to the USL. And moreover, Mr. Donald knew at the time that Mr. ENG had spoken to and was speaking directly with USL, and Mr. Donald never complained about it. He never sent an email to Mr. Or made a phone call to Mr. ENG and said, Kyle, I don't want you talking to the USL directly. Nor did he send an email or a text or talk to Mr. Tim Holt or anybody else at the USL to say, hey, USL, you are talking to Kyle Lang, and I don't want you doing that. That's wrong. Nothing in the record about that. But there is something in the record to show that Mr. Donald knew that they were talking directly. In fact, starting in January, there's a January 28, 2014 email from Tim Holt to Mr. Donald, enclosing a copy of an email exchange directly between the USL and ENG. And in that email, Mr. Holt says, oh, sorry, I forgot to send this to you, Tim. Here's a copy of the email exchange we had with Kyle Lang. So that was on January 28th. And then that was the first time, at least by that date, Mr. Donald knew there was direct talks between them. And then again on February 7th, just 9 days later, you'll recall in the briefing that the USL sent a text to Mr. Donald saying, in effect, hey, Tim, I guess you're aware that Kyle Lang is going to be meeting with us with the USL here in Tampa today. And Donald texted him back and said, no, actually, I wasn't aware of that. But tell me how the meeting went. Is Mr. ENG happy? That's important, because Donald didn't text back and say, no, I forbid you to meet with him. Not that he could have forbidden. There was no, he had no power over the USL to forbid them from talking to someone. But the more important fact is he expressed no concern about it other than to say, gee, I hope the meeting went well and that Mr. ENG is still happy with things. So there was nothing wrong with Mr. ENG talking directly with the USL. And Donald knew he was talking to them and did nothing to stop it. The claim, the mere claim that Mr. ENG told the USL, gee, I would be a better franchisee than Mr. Donald. So what? He has the perfect right to tell the USL that if he wants to. And as a matter of fact, from the USL standpoint, consider their position. From the USL standpoint, Mr. Donald was quickly put in place as a franchisee effective December 5th of 2013. And the USL and Mr. Donald knew that there was only 4 months remaining until they had to start a new soccer season, because they had previously terminated BDR, the former franchisee, because there were some problems there. So so they I don't know what that sound was, but
You're fine.
okay. So
And you have 4 minutes.
thank you. That made me momentarily lose my train of thought. But in any event, I was considering the USL's position. They knew, and Mr. Donald knew, that he needed to put up a $50,000 franchise performance security fee, and he hadn't done it yet. Now, the USL gave him credit for part of that, using the balance from the prior franchisor or franchisee's security. But Mr. Donald still owed over $25,000 as performance security. And if you read the arbitration panel's final award, they specify with great detail how the USL, starting in January of 2014, repeatedly asked Mr. Donald to pay that. And Mr. Donald repeatedly came up with excuses. And those excuses were, I mean, he would say, oh yeah, I'm going to get around to it. I just haven't done it yet, but I'm going to. Here's a quote from the arbitration final award. Quote, the evidence reflected that Donald repeatedly promised to deliver the performance security, quote, next week, ASAP. And then he told USL that he would promptly follow up with payment in full. Then the record goes on to say, or excuse me, the arbitration award goes on to say, the record evidence conclusively established that the claimants were fully aware of their contractual obligation to deposit the performance security, yet they continued to postpone performance of this contractual duty. And then, so the USL is trying to get Donald to pay, and he doesn't, and he won't. And finally, on February 14th of 2014, they send him a letter. It's a demand letter to pay up, or they're going to terminate him. And in fact, they say in the letter, we could actually terminate you right now, immediately, under the provisions of the franchise agreement. That letter is at APP Appendix 154. They say we could terminate you right now, and then they underline this statement. Please note that Section 11.2.2H of the franchise agreement allows for immediate termination of the franchise agreement without cure for this default. This default meaning a failure to pay the performance security. So here's the USL. They've asked and asked and asked Mr. Donald to pay. He said, oh yeah, I will. He doesn't. They finally send him a default letter. And they say, by the way, we could terminate you now, but we'll give you 7 more days. Does Donald rush out and pay? No, he doesn't. He does not pay. And then there's a February 24th meeting, and at that meeting, what happens?
Counsel, you have 1 minute remaining.
Thank you. At that meeting, they terminate him. And by the way, at that meeting, Mr. Donald didn't say, oh, wait a minute, that performance security isn't due yet. In fact, he brings some checks to try and see if he can belatedly pay it. But you'll recall in the briefing that checks were bad checks. They were not valid tender. He didn't have the funds in the bank to do it. And then after all of that, what happens a few years later, he brings this lawsuit and he tries to blame my client, Mr. ENG, for his failure to pay the fees that he needed. If I were, one can imagine if you're the USL, you might not be too excited about getting a franchisee on board with that history of non-payment. So I would urge you to affirm the trial court. I'm happy to answer any more questions. Otherwise, I thank you.
Thank you, counsel. Let's see, Mr. Murray, you have 18 minutes.
Well, I I think that the thing that I want to point out is that these franchises, these soccer franchises, the way they worked is that you paid a franchise fee of $500,000 for a 3-year franchise. And that franchise lasted for that period of time. Tim Donald was credited with the $500,000 plus that he had put into the soccer franchise to keep it afloat the year before. And they credited him with that $500,000. The second they took that franchise back, the 2 leaders of the USL, Mr. Holt and Mr. Papadakis, as well as Mr. ENG, Mark's client, divided up the $250,000 franchise bonus into 2 $250,000 amounts and credited that to themselves. Kyle Lang only paid $250,000 for the franchise because of what Tim Donald had put in. Mr. Papadakis and Mr. Holt withdrew $250,000 between them. I just want to point out that this didn't all go down according to the way Hoyle would have dictated it, and we've got that set forth in our brief. Thank you very much.
Judge Howe, you're muted.
Counsel, given the ruling in the arbitration, how have you overcome that?
The ruling in the arbitration as to the underlying damages applies a standard in Florida that is so severe in terms of the wheels of justice operating in this case that it really should not be sanctified. And on top of it, there are the legal expenses that Mr. Eng turned to my client and asked him to shoulder in connection with this matter as well. It wasn't enough that he was going to go out the door. He knew when he was negotiating with him and having that handshake deal that he wasn't going to carry through with the deal. He knew that. But on top of it, he had to get him to go out and hire his lawyer to create a stack of what they said was about 3 inches of franchise documents to effectuate the deal. And that's a cost. That's a damage.
Thank you.
I don't have further questions. Mr. Murray, if you have anything else that you would like to alert us to or point to, unless Judge Cruz or Judge Howe, you have further questions.
No, thank you.
No, I do not, Your Honor.
Okay. Well, I would like to thank you both for your patience and participation. We appreciate your indulgence in this unusual time. Thank you also for your arguments. We are taking the matter under advisement and will issue our decision in due course. And with that, court is adjourned.
Thank you.